First up, we absolutely have to start with Article 142 of the Constitution. This is like the powerhouse provision for the Supreme Court. What exactly does it let the court do?
Right, it's often called the catch-all power. Basically, it lets the Supreme Court pass, well, any order it thinks is necessary to achieve complete justice in whatever case is in front of it.
Any order. That sounds incredibly broad.
It is, and it's quite unusual. Yeah, you don't really find a direct comparison in places like the US or the UK.
So what's the thinking behind it? Why give the top court this kind of escape hatch from the strict letter of the law?
The idea basically is that sometimes following the law to the letter, well, it might not actually lead to a fair result. Article 142 lets the court prioritize the spirit of justice, if you will.
Okay, that makes sense. And we saw a really clear example of this just recently, didn't we? The Shilpa Shailesh case from 2023.
Exactly. That was a perfect illustration. The Supreme Court used Article 142 to grant a divorce immediately. They actually bypassed the normal 6 to 18-month cooling-off period needed under the Hindu Marriage Act.
Why?
Because the court recognized the marriage had irretrievably broken down. Making them wait just wouldn't have served any real purpose. It was about delivering complete justice then.
And this wasn't a one-off, right? This power gets used in major cases.
Oh, definitely. Think about the Janmabhoomi case in 2019, or the release of AG Perarivalan in 2022. Article 142 played a role in those big moments, too.
But, with great power comes great criticism, right?
Right.
What are the main worries about Article 142?
Well, the big ones are that it's potentially arbitrary. I mean, what is complete justice? It sounds a bit vague, maybe subjective.
Right. And there's no appeal from the Supreme Court.
Exactly. So that raises questions about accountability. Plus, it can create uncertainty, A lawyer can't always predict if or how the court might use this power.
Okay, but the court itself has recognized this, hasn't it? It's developed some internal guidelines, some sort of self-restraint.
Yes, absolutely. Over the years, through various judgments like Prem Chand Garg back in '62 or Uma Devi in 2006, the court has said, look, this power is broad, but it can't fundamentally contradict the Constitution.
And didn't the SC Bar Association case in '98 put a key limit on it?
It did. It basically said Article 142 can't be used to completely replace existing law or build a new edifice where none existed. It's meant to supplement, not supplant.
Yeah.
And crucially, justice must be according to law, not just sympathy.
Okay, so if the court has this massive power, the next obvious question is accountability. Let's move to judicial accountability. Arrest and in-house procedure. Why is it that regular police, the executive branch, can't just arrest a judge if they suspect a crime?
Well, it boils down to protecting judicial independence. It's a core part of the separation of powers. If judges constantly feared arrest by the police, it could really undermine their ability to make decisions without, external pressure.
So there are special rules. What about for the top judges, Supreme Court and High Court judges?
Right. The Veeraswamy case in 1991 set the standard. Basically, no FIR can be registered against them, and no arrest can happen without getting permission directly from the Chief Justice of India, CJI. That's a pretty high bar.
A very high bar. And what about these subordinate judges, the district judges? They're more sort of on the front lines.
Yeah, for them, the Delhi Judicial Officers Association case, also from 1991, laid out really strict protections. If an arrest happens, the district judge or high court must be told immediately.
An arrest is only a last resort.
Only as a last resort. And crucially, the arrested judge can't just be taken to a police station. You need prior orders from the district and sessions judge. They can't be handcuffed.
Wow, no handcuffing.
No handcuffing. And they have the right to talk to family, get a lawyer, and importantly, no statement can be taken without their legal advisor present. It's quite comprehensive protection.
Okay, that covers potential criminal issues.
Yeah.
But what about ethical problems, misconduct, corruption allegations against High Court or Supreme Court judges? There's this internal process, right? The in-house procedure.
Yeah, set up in 1990. It's basically the judiciary policing itself. The CJI forms a committee of judges to investigate allegations.
And what can that committee recommend?
Well, if the allegations are trivial, they're dropped. If they're substantial, the CJI might authorize an FIR. For minor misconduct, maybe just some advice or an official reprimand.
And if it's serious enough for removal?
Then the matter typically goes to Parliament for impeachment. But here's an interesting point. If Parliament doesn't act, the CJI still has a tool. They can advise the judge to resign, or, failing that as the master of the roster, they can just stop assigning any cases to that judge. Essentially, take away their work.
But this whole in-house procedure, it's faced criticism for being, well, pretty opaque, hasn't it? The case involving the former CJI in 2019 brought this out.
That's a key example, yes. The core issue there was kind of hypocrisy. The complainant withdrew because she wasn't given basic procedural fairness, things like having a lawyer present, a support person, getting recordings.
Things that the Supreme Court itself insists on for other workplaces under the Vishaka guidelines.
Precisely. So the judiciary's own internal process didn't seem to meet the standards it set for everyone else. That raised serious questions about transparency and fairness within the system itself.
Which leads us nicely into the next topic. Ethical standards. Let's look at the values of judicial life. This is a document the Supreme Court adopted back in 1997, right? A sort of code of conduct.
Exactly. It outlines behavioral norms. And the guiding principle is fundamental. Justice shouldn't just be done, it must be seen to be done. Public trust is paramount.
So it creates this idea of a judicial bubble, keeping judges slightly separate.
That's a good way to put it. It imposes some pretty strict rules to avoid even the appearance of bias.
Like what? What are some of the key restrictions?
Well, judges shouldn't contest elections, even for, say, a private club, unless it's law-related. They need to avoid close friendships with lawyers practicing in their own court.
And the rules about family are quite strict too, aren't they?
Very. If a family member is a lawyer, they can't appear before that judge. The judge has to recuse themselves. And that family member practicing law can't even live in the same house as the judge.
Wow. And this idea of aloofness.
Yeah, it basically means judges should practice a certain degree of social distance. Avoid too much partying or socializing where influence might be perceived.
And they shouldn't weigh in on public debates.
Right, especially not on political matters or cases that are currently in court, sub judice. The idea is let their judgments speak for themselves. Avoid media interviews about their rulings.
Any other key things? Conflicts of interest.
Yes, absolutely. They must disclose conflicts, like owning shares in a company involved in a case before them. And they shouldn't be like day trading stocks or running other businesses, apart from maybe legal publishing.
Okay, let's shift gears to how judges get appointed, specifically the top job. Appointment of CJI based on seniority. Now, this feels like a core principle, but it's actually just a convention, isn't it? Not explicitly in the Constitution.
That's exactly right. Article 124 talks about appointing Supreme Court judges generally, but there's no separate clause just for the Chief Justice. This seniority convention really started back in 1951.
How did that happen?
Well, the first CJI, H.J. Kanai, died. P.M. Nehru actually wanted someone else, Justice Chagla. But the senior judges on the court protested, insisting it had to be the most senior judge, who was Justice Patanjali Shastri. And they won that argument.
And the Supreme Court later gave its official stamp of approval to this principle.
Yes. In the second judge's case, in 1993, the court basically codified this convention. Seniority became the rule.
But conventions can be broken. History shows that, right?
Oh, absolutely. The executive has ignored it on occasion, most famously in 1973 when Justice A.N. Ray was appointed CGI, superseding 3 judges senior to him.
Grover, Hegg, and Shalat.
Right. And again in 1977, Justice M.H. Begg superseded Justice H.R. Khanna. So while it's a strong convention now, it hasn't always been unbreakable.
And even with the convention, can the executive still sort of subtly influence who ends up being senior, maybe if judges are appointed around the same time?
Yes, there's a potential loophole there. They could, for instance, issue the official warrants of appointment on slightly different dates, or even just manage the order in which judges take their oath if they're all appointed on the same notification date. It allows for a bit of maneuvering, potentially.
Let's move down the ladder now to the district judges, really the backbone of the system. Topic: Judicial Pay Commission and status of district judges. Their pay is recommended by these national judicial pay commissions. Right?
Correct. Like the second one headed by Justice Venkat Ramareddy in 2017, they recommend pay scales and perks.
But there was a recent tussle with the state governments over implementing these recommendations. What was the issue?
The core conflict was about parity. States were dragging their feet, arguing that the recommended judicial salaries were getting higher than those for top civil servants, like IAS or IPS officers in Group A.
They wanted to keep judicial pay tied to executive pay scales.
Essentially, yes. But the Supreme Court stepped in quite forcefully in the All India Judges Association case just this year, 2024.
And what did the SC rule?
They completely rejected that parity argument. The court made a crucial distinction. District judges are not government employees. They are holders of public office who wield sovereign judicial power.
So it's a fundamental difference in their role and status.
Exactly. The court said judicial independence demands that their pay reflects this unique status. It shouldn't be benchmarked against state bureaucrats. They're a separate pillar of the state. Okay, let's talk about the body responsible for suggesting changes to the law itself. The Law Commission. What's its formal status? Is it created by an act of Parliament?
Surprisingly, no. It's not a statutory body. It's actually set up as an executive body by the government. The first one, post-independence, was back in 1955, chaired by MC Settlefed.
And who typically sits on it?
Usually there's a full-time chairperson who's a retired or maybe even a serving Supreme Court or High Court judge, plus four other full-time members, and secretaries from relevant government departments are also involved.
And its main job is law reform, keeping laws up to date, making justice work better.
That's the goal: promoting good governance, reviewing old laws that need repealing, looking at laws that particularly affect the poor, examining issues in judicial administration like case backlogs, and simplifying central laws.
And it's had some major successes over the years, hasn't it? Oh, absolutely. Historically, its recommendations were key for foundational laws like the Indian Penal Code, the Criminal Procedure Code, the Evidence Act. Those originated in the British era. The Commission played roles in their updates.
And more recently,
More recently, its reports were crucial for things like the Right to Education Act 2009, the National Green Tribunal Act, and it's overseen the repeal of, I think, over 1,500 outdated central acts. So really vital work.
but because it's an executive body, not statutory, appointments can get delayed, right? There can be big gaps between commissions.
That's a recurring issue, yes. Sometimes there are significant delays in appointing a new chairperson and members after one commission's term ends.
So does that raise a critical question? Should it perhaps be made a statutory body to ensure it runs continuously and is maybe a bit more insulated from government delays?
That's definitely a point of debate. Making it statutory could potentially provide more stability and prevent these long gaps. It's something policymakers could consider.
All right, let's talk about moving judges around. Transfer of high court judges under Article 222. What was the original idea behind this power?
Well, Dr. Ambedkar initially suggested it as a way to maybe strengthen high courts that were considered weaker by bringing in talent from elsewhere.
And how is it justified now?
The justifications have sort of evolved. One is national integration. The idea that maybe at least a third of judges in a high court should be from outside that state to foster a broader perspective. And then there are vaguer reasons confirmed in the Ashok Reddy case, 1994, like serving the public interest or for the better administration of justice.
This power wasn't used much initially, was it?
No, for the first 26 years or so, only about 25 transfers happened. It was pretty dormant.
But then it really ramped up.
It exploded in 1976, 76 transfers in just 1 year. And we've seen surges more recently, too. Between 2017 and 2021, there were 89 transfers. Apparently, 31 happened in just 1 month, September 2021, which some people called Bloody September.
Wow. Does the judge being transferred have to agree to it?
That was clarified in the Sankaltan judgment back in 1977. Their consent is not essential. However, their views must be sought and considered as part of the process.
Okay, but here's the rub, isn't it? Often, the reasons for these transfers aren't made public, even when they say it's for public interest. Why the secrecy?
And that's the core criticism. The lack of transparency breeds suspicion. People wonder if transfers are being used punitively, maybe to move judges who made inconvenient rulings, or for political reasons.
Can a judge challenge a transfer order in court?
They can, yes, in the Supreme Court. But the grounds for challenge are quite limited. Usually it's only successful if the proper procedure wasn't followed, like if the CJI didn't do the mandatory consultation with the Chief Justices of both the High Court the judge is leaving and the one they're going to, or if other parts of the detailed procedure weren't observed.
Let's talk about language now, specifically judicial language. Topic: obiter dicta. Sounds fancy, but what does this Latin term actually mean?
It literally means things said in passing. In a judgment, these are remarks or observations made by the judge that aren't strictly necessary for the final decision itself. They're not the legally binding part, the ratio decidendi.
So they don't set a legal precedent? Lower courts don't have to follow them.
Correct. They aren't part of the official enforceable record in the same way.
Then why do they matter? If they're not binding, why are we discussing them?
Because judges' words carry immense weight, even when they're just said in passing. Strong negative comments like if a judge says, people like you should be dealt with very sternly, while denying bail can seriously prejudice public opinion against the accused.
Right, it could influence the actual trial later on.
Exactly. It can compromise the objectivity of the trial in the lower court. It might signal an institutional leaning even before all the evidence is heard.
There was that big example during the pandemic, right? The ECI versus Vijay Bhaskar case in 2021.
Yes. That's a prime example. The Madrid High Court made some really strong remarks, suggesting maybe even homicide charges should be considered against the Election Commission because of how political rallies were handled during a COVID wave.
And the Supreme Court had something to say about that.
It did. While dealing with the ECI's appeal against those remarks, the SCI advised judges generally to be cautious with their words. Obiter dicta can be easily taken out of context or misrepresented, and they carry significant weight, potentially undermining public trust.
Okay, let's shift to alternative ways of resolving disputes, starting with look adalats. These are ADR mechanisms, right? Alternative dispute resolution.
Correct. They focus on getting parties to reach a compromise or settlement, mainly for civil cases and also for criminal offenses that are compoundable, meaning the victim can agree to drop the charges, usually with some compensation.
And they serve a constitutional purpose too.
Yes, they're seen as helping fulfill Article 39A, the mandate for free legal aid and access to justice. The big plus is that both sides can potentially walk away with something, unlike a regular court case, which often has a clear winner and loser.
And they handle a massive volume of cases.
Huge volumes. You mentioned it earlier, a recent national look at a lot apparently settled over 1 crore cases in a single day. Though, it's worth noting, a lot of those, maybe 90%, were pre-litigation, meaning they hadn't formally entered the court system yet.
And they're also specialized ones. Permanent look at a lot, PLAs.
Right. Those are specifically mandated to handle disputes involving public utility services, think banks, insurance companies, telecom providers, electricity boards, that sort of thing.
But there are issues here too, right? What are the main criticisms?
Well, first, implementation of PLAs is patchy. As of 2023, about 12 states and union territories still didn't have functioning PLAs.
Okay. And the other criticism? About the nature of the compromise.
Yeah, some argue that lookout lots can be, quote, alien to the language of rights. The concern is that litigants, particularly those who are poor or less educated, might feel pressure to accept a quick compromise just to end the hassle and expense of fighting a case.
Even if they might have a strong legal claim.
Potentially, yes.
Yeah.
Especially when they're up against big institutions like banks or corporations who have lawyers and resources, they might end up giving up rights they're legally entitled to just for a quicker, albeit smaller, resolution.
Let's look at another ADR mechanism aimed at rural areas. Gram Neolaas. The idea sounds great, bring justice closer to villages.
Absolutely, a noble goal. It was proposed way back in 1986 and finally established by the Graham-Nealaas Act in 2009. They're meant to be set up at the Panchayat Samiti, or block, level.
And they're supposed to be quite accessible, mobile courts?
Yes, they're headed by a judicial officer called a Nyadhikari, appointed by the state government after consulting the High Court. And the key feature is that they are required to hold mobile courts in villages and actively encourage conciliation.
So, great idea. But how's the reality? How's the implementation?
Unfortunately, it's quite weak. This is a major issue. First off, the act itself is non-mandatory. It's optional for states to set them up.
Ah, so not all states have even notified them.
Exactly. By 2023, only about 15 states had actually done so. And even where they've been notified, the operational rate is low.
How low?
Well, at around 470 that were notified, only about 264 were actually functioning.
And the case disposal rate? You mentioned some figures earlier.
Yeah, the pendency is massive. In 2023, they reportedly received something like 2.16 lakh cases, but only managed to dispose of about 6,300. That's not really working effectively, is it?
Not at all. What's holding them back? Is it money?
Finance is a big part of it, yes. The central government provides some initial funding, about 27 lakh, and helps with running costs for the first 3 years. But after that, the states are supposed to foot the bill.
And many aren't.
It seems many struggle with funding, leading to lack of proper infrastructure, staff shortages, and so on. Plus, there's sometimes confusion about which cases they should handle, especially where their jurisdiction might overlap with specialized courts, like family courts or labor courts.
Okay, for our final topic, let's look at that persistent friction point between the executive and the judiciary at the state level. Governor's assent on bills and extra constitutional rules. Article 200 seems clear the governor has options, but sitting on a bill indefinitely isn't one of them, right?
That's the constitutional mandate. They shall declare assent, or withhold it, or return the bill for reconsideration, or reserve it for the president. Indefinite delay isn't supposed to happen.
But it does happen, and the Supreme Court has had to step in recently, like in the Punjab case in 2023.
Yes. In that case, the SEC made it clear that the governor couldn't refuse to act on bills by questioning the legality of the assembly session itself, especially if the session was just adjourned sine die and not formally prorogued by the governor. The governor's job was to act on the bills passed during that session.
And then there was the Tamil Nadu case in 2023, spilling into 2024, which dealt with what happens when a bill is sent back and then repassed by the Assembly. What did the SC rule there?
That was a very significant ruling. The SC said if the governor returns a bill and the Assembly passes it again, the governor then loses the option to reserve that repassed bill for the president. They must give their assent at that point.
So it really limits the governor's ability to stall legislation passed by the elected government.
Precisely. It closes a potential loophole for indefinite delay on repassed bills.
Now, there's another area of friction. The governor's role as chancellor of state universities. This isn't in the Constitution, is it?
No, it's typically granted by state university laws, state statutes. Traditionally, this gives the governor the power to appoint vice chancellors, VCs.
And state governments often want to take this power away.
Yes. Many argue it's an extra-constitutional role, giving the governor executive power outside their defined constitutional duties, and they feel the elected government should have control over university appointments.
But there's a legal complication here. Something about state statutes versus constitutional advice.
Right. The Bolinath case from 1997 is key here.
Mm.
The SC ruled that when a governor exercises powers granted by a state law, like a university act, they are not necessarily bound by the advice of the State Council of Ministers in the same way they are for their constitutional functions.
So that gives them a degree of independence in these statutory roles, which creates political tension with the chief minister.
Exactly. It remains a major source of friction in governor-state government relations.
Wow, we have covered a huge amount of ground today. From the Supreme Court's sweeping powers right down to the challenges faced by village courts and the governor's office. This deep dive should really give you, the listener, a solid handle on India's complex legal landscape.
I certainly hope so. And just to help lock it all in, maybe a quick recap of the main points we hit for active recall.
Great idea. Go for it.
Okay, so Article 142. The SC's omnibus power for complete justice, letting it prioritize the spirit over the letter, like in the Shilpa Shailesh divorce case, but criticized for vagueness. Judicial accountability. Special rules protect judges from easy arrest to ensure independent CGI approval needed for HCSC judges. Strict protocols like no handcuffing for lower court judges. In-house procedure. The judiciary's internal investigation mechanism for misconduct. Controversial due to lack of transparency, as seen in the 2019 case where it arguably didn't meet Vishaka standards. Ultimate non-parliamentary action is withdrawing work. Judicial values. The 1997 code emphasizes appearance of justice, requiring judges to be somewhat aloof, avoid conflicts, especially family ones, and let judgment speak for themselves. CJI seniority. A strong convention, not a strict constitutional rule, established in 1951 and affirmed in 1993, though it has been broken historically. District judges' status. Crucially, they're not government employees but holders of public office with sovereign judicial power, so their pay shouldn't be tied to the executive. That was the 2024 All India Judges Association ruling. Law Commission. An important executive, not statutory, body for law reform behind IPC, RTE, NGT Act, etc. Its non-statutory status can lead to delays. Transfers. Art of 222. Used for various reasons. Integration, public interest, judges' consent isn't needed, but consultation is. Lack of transparency about reasons is a major issue. Obiter dicta. Non-binding things said in passing by judges. Need caution as they can still influence perceptions in trials despite not being law. ADR. Look adulats. Provide mass settlements but risk compromising rights for speed. Graham Nihileas are a great idea but failing badly due to the law being optional and funding infrastructure caps. Governor's role. Art of 200. Governors must act on bills, can't sit indefinitely. Crucially, they cannot reserve a bill for the president if the assembly has already repassed it. The chancellorship role remains a friction point due to powers derived from state laws.
That's a fantastic summary. It really highlights the constant balancing act. So what does this all mean for you, listening in? It really boils down to a fundamental question for any democracy, doesn't it? When do you prioritize the predictability and stability of sticking strictly to the established laws and procedures?
And when do you allow for the flexibility, maybe the necessary flexibility of something like complete justice under Article 142, or even just rely on a judge's careful interpretation and language to guide the outcome? Where do you draw that line?
That's the tension, isn't it? Stability versus flexibility, something to definitely chew on.
Indeed. Food for thought until our next deep dive.
Thank you so much for diving deep with us today. We really hope you feel thoroughly informed.